and so we will call number 52673, Hugh M. Hodges. And we will hear from Mr. Hodges, who asked for 20 minutes, I believe. And Ms. Hamilton said she needed about 10. And if we can note that Mr. Hodges asked for a 5-minute warning, and I'll try to make note of that as well, so that he has 5 minutes for rebuttal.
You do want to do it from Mike?
Yes, please.
May it please the board. The first thing I want to say is, I mean no disrespect by not having a tie. I left Dallas very early this morning, and I got out without a tie.
Thank you.
I have filed a brief that I had to make a few changes to, and I will advise you of them as I go along. On page 2, there was a mistake in the printing, in the word informed. It came out informal. It was supposed to be informed. And at the bottom, after the last paragraph, there should be a paragraph 3. That should say the point relating to Rule 114A, page 64, line 22 to 25, page 9 of my brief, and page 65, line 1 to 6 in the brief. The professional misconduct was violation of Rules 101B, 103A, 103B, 114B, 115D, and 804A. The panel found violations of 103B, 114A, which was pled in the second amended petition. In my brief, I said they only went to the first amended petition, but they went to a second one, and that was included in the second one. And 804A. The result of the panel's decision was that I was given a 3-year active suspension. Attorney's fees in the amount of $3,328.75 were awarded. Cost in the amount of $297.35, and restitution in the amount of $2,750 to one to wear. I made 4 points on appeal. I alleged that the panel, and I called it the commission in each of those points, but it's the panel. The panel erred in finding that the matter was not explained to the extent necessary for the client to make informed decisions, that Rule 114A was violated, that the panel erred in finding a violation of 115D relating to a lawyer's duties upon termination of employment, and the panel erred in the interpretation of Rule 804A. Mrs. Ware came to see me. Her son was in custody in Dallas County. He was charged with a felony, with a paragraph, with an enhancement paragraph. His bond was set at $50,000. Ms. Ware gave me a $750 retainer. I was authorized to post bonds for people that came to me under my own account if they were my client, not someone off the street. It had to be someone who came to see me and not just someone who wanted a bond. I advised Ms. Ware what I advised everyone in that situation, which was that I'll charge you a retainer. If I can get the bond reduced, that's very good. And we'll apply that $750 retainer toward the fee for posting the bond, which in this case was $5,000. That was adequate with her. I had to tell her that if that was not successful, if I could not get the bond reduced or couldn't get it reduced far enough, that she would still get credit for the $750 toward posting the bond in either the lower amount or the higher amount. And if none of those things were available, I would give her $750 credit toward representation. Ms. Ware says that she has no complaint about not being informed. I think that means that she was told what happened. I think that the panel believed that I had not told her what was going on, but I in fact did, and I was very careful to go over this with her. And I think this is a very good thing for her and her son, because they were getting credit for that $750 no matter what. It was either going to get a bond reduced, or it's going to get it posted, or it's going to go for representation. I was not able to get it reduced. There's a bond schedule in Dallas County for the charge that he had with his previous record, which is 9 previous felonies and 2 previous misdemeanors. The bond was set at $50,000. Criminal District Court number 6 would not reduce that bond. I talked to Ms. Ware again, told her what was going on. Excuse me. I told her that if she wanted to post a $50,000 bond, I could do it, but I'd have to have $4,250. The difference between $5,000, which is 10% of $50,000, and the $750 she'd paid. She said she couldn't get it all at once, but she could get $2,000, and that she would work on the rest. She did, in fact, give me $2,000. The receipts that I think are included in the paperwork here show that she made a $750 retainer payment. She made a $2,000 payment on her account. She never came to see me again. Evidently, she hired another lawyer at the end of the calendar year 2011. But she did not advise me of that. He was indicted on January the 10th. On January the 20th, he had a first sitting. This is 2012. And he had a court-appointed lawyer at that time. Sometime after that, Ms. Blair hired a lawyer whose name is Cox, I believe. And he represented him through the case and did a very good job. He got one of the paragraphs dropped, and he got the bond reduced, and he got a bond posted. And I commend him for doing it. He did a better job on getting the reduction than I did. But I don't believe that I violated that rule, because I did explain to her what was necessary for her to make informed decisions. That's exactly what I did, and I was very careful to do that. Now, the second violation the panel found was that excuse me, I've got them in order here. That I did not keep payments made to me in a separate account, which I believe the civil lawyers call an IOTA account. And I don't have an IOTA account, and I've had that reviewed several times, because criminal lawyers traditionally do not have money that belongs to someone else. The only way we can live is if we take a retainer, and that retainer is not refundable. As a matter of fact, though, even though I didn't want to refund it, I was giving her credit for it on helping her son. I don't think that a person in my position should be required to put all of the money in the bank and withdraw some every time I use the phone, or talk to a prosecutor, or talk to the judge, or talk to the defendant, or talk to the defendant's mother. I've practiced criminal law for over 20 years, and this is the way it's done in Dallas County, Texas. Criminal lawyers do not have an IOTA account for criminal retainers. I would direct your attention to page 64 and 65 of the transcript. The bottom of page 64 and the first 6 lines, 65. She was asked, Ms. Ware was asked, but you didn't, I was asked, but you didn't deposit that into your trust account? You didn't consider that to be possibly unearned? No. But you were going to credit toward paying the bond, so are you saying it was all attorney's fees? This is my response. Well, I'm saying that it was attorney's fees, which first went toward trying to get the bond reduced, second toward posting a bond under my name, and third, representation of neither of the above, or neither of those occurred. Third allegation is that I did not give Mr. Ware or his mother adequate time for representation and refund of advance payments. I think it dealt only with advance payments. There were no payments other than the 2 payments that were made, and those were used for the purpose that I set forth. I didn't understand really why she hired another lawyer, since she'd already paid me $2,700 toward reducing the bond, posting the bond, representing him, whatever he needed. But she did. Mr. Ware was indicted on January the 10th, 2012. He had a court-appointed lawyer, appeared twice for him. I appeared both times, but Ms. Ware had never told me whether she wanted me to represent him or to post a bond. Meanwhile, I had continued to try to get the bond reduced. I had talked to the prosecutors about a plea bargain agreement. I had talked to the grand jury assistant district attorney to see if they were going to indict him, and if they were, could we get one of the paragraphs dropped. So I put in a substantial amount of time on this, and I don't think there was any unearned fees. Now,
were you putting in this time unbeknownst to you that she had hired another attorney, or was it the attorney hired after you ceased doing your work?
The attorney was hired after December the 14th, which is when she made the $2,000 payment. Sometime between December 14th and evidently sometime in February.
I thought he was court appointed.
The first lawyer was court appointed, and I think that was a lady, but she appeared twice, and the cases were passed to hire an attorney, which I thought meant to pay me some more money or to get someone else. She never asked for her money back. She never asked for anything back. I don't think she was entitled to it, but she never even asked for it.
Mr. Hodges, at the time that you undertook the representation of Wanda, were you administratively suspended by the state bar from practicing law?
I was behind on my fees when I aware of that sometime in December. I didn't do anything again after that, and I paid, and that administrative suspension was removed, and I was never asked to respond to anything for that. And my understanding is that upon paying of those back dues, then the suspension is backdated to the time it was handed out.
You recall when your dues were to be paid and how long you were behind in paying them?
I was behind. You know, there's several fees that we have to pay every year, and I really don't remember which one. I think one of the two, either the attorney tax or the bar dues, were behind.
I think those come out in June, or payable by June 30th,
Yes.
is my recollection.
I believe so.
And they were not paid until the end of December, is that what I'm hearing?
They were paid in December, yes.
So perhaps for 5 or 6 months you were behind, hadn't paid.
I think that is probably true.
And
Of
can you
course,
tell
that
us the
wasn't.
reason, why did you not pay them?
I don't remember, to tell you the truth. My birthday is in July, so that comes due at the same time, and I'm obviously not very good at keeping up with that. But I was not. That's not what the panel was. They were not asked about that. I'm not going to tell you that I wasn't behind, because I was, but the panel didn't have any evidence on that. There's no testimony on that. It's not in this matter.
It is finding of fact number 6, though.
From the panel.
From the panel.
I believe they said I was behind.
No, it says respondent engaged in practice law when his right to practice had been administratively suspended for failure to timely pay required fees.
I believe that must have been in the second amended petition. When I prepared my brief, I was only dealing with the first amendment. So
All right.
I went over that, I guess.
Thank you.
I'm contending that the panel erred. But by going over it, I mean I didn't deal with it in my brief.
Excuse me, Mr. Hodges. Was there ever a contractual agreement between you and Mrs. Ware?
There was not a written contractual agreement.
There's no paper that we can read to establish what the agreement was for what you were being paid to do?
No.
Mr. Hodges, was your practice 100% criminal defense?
Yes.
Do you ever get a written agreement, an engagement letter?
I do sometimes, but because of this man's 11 previous convictions and he knew what we're talking about. I went to see him, and I think you'll see in the transcript that he said I read the paper or touched my beard or something, which of course is just foolishness. I didn't do that. I wouldn't have gone to see him if I was going to read the paper. I explained to him what I had talked to his mother about and what she wanted me to do. It was oral.
Do you ever spell out your fee agreement with whomever it is in writing?
I do sometimes, yes. I do sometimes, and I didn't this time.
Mr. Hodges, you know about the ongoing potential ethical problem with lawyers making bonds. You know about that, right? Are you their bondsman or are you their lawyer?
Yes.
And you know that's debated all the time, that lawyers continue to make bonds, but at the same time that there's been lots of lawyers that have gotten in ethical trouble because if they miss their bond payments, then they go off their bond, and they're also their lawyer, and that's the problem. Who are you? Are you the bondsman or are you the lawyer? And in this case, I mean, you took a very low amount of money to make a pretty high bond to start with. Would you agree with that?
Well, the original payment was just hoping that I would get a reduction. I don't think that Ms. Ware had any...
Did you have a bond reduction hearing?
No. In the practice in Dallas County is to approach the assistant district attorney to see what his or her position is. If it's not agreeable, have an informal hearing in front of the judge, and the judge tells us, I'm going to follow the schedule, or I will consider it, or you need to get a hearing. And most of the time...
Did you do both those things?
Oh, yes. I don't ask for a hearing if the judge has told me it's going to be fruitless, because I see no reason to run the meter for the person when it's not going to do any good. And the judge in this case had told me that it was not going to help, that the bond was going to stay at $50,000, which was the scheduled amount.
Okay.
And I've never gone off a bond. I've posted bonds in my name for probably 20 years.
But you never made the bond in this case.
That's right. I didn't make the bond in this case, but you rightfully brought up the fact that was a problem, is that some lawyers evidently were making bonds, going off the bond when they didn't get paid something. And I just wanted the board to realize that I've never done that. And I lost money on people because they didn't pay or they didn't go to court.
What was the $2,000 for?
The $2,000 was to either pay part of the $4,250 that was necessary to post a $50,000 bond, or if she didn't want to do that, to go toward representation, in which case her son had a $2,750 credit.
But what is a partial bond?
Well, there's no partial bond. It was $50,000 or nothing.
But so I don't understand what the $2,000 was then.
She said that she could not come up with $4,250 in one amount. So she would have to make two payments.
Okay, so you took $2,000 as a down payment?
I took it as a payment on the continuing representation.
But I thought it was to go to the bond if you could get it reduced. If she could come up with the additional money, I thought that $2,000 plus the additional money would do the bond.
Well, it would pay for what's called bond premium, or the charge.
Oh, I understand that.
Yeah.
That's what that money was to go for.
That was the $750 was never anything except to try to get the bond reduced. When that was unsuccessful, then I went to the next step, which was, Ms. Ware, do you want to post a $50,000 bond, or do you want me to represent your son while he's in jail?
Tell me the $2,000 though. What's the $2,000 for?
That is about, 45% of $4,250.
So that was to go towards the bond.
That was, we get into the problem that this gentleman brought up there, which is sometimes it's difficult to tell what shoes a person's wearing who has the authority from a sheriff to post bonds in his name.
But if it's not your shoes, you can't wear them. If it's not your money, you can't have it.
No.
The $2,000 has got to be for something. What was it for?
Because she did not pay the rest of the balance.
Forget
Because
about
of
what
that,
happened later. What was the $2,000
When-
for at the time you got it?
The $2,000 at the time I got it, I thought was to post a $50,000 bond.
Wasn't her
She didn't
testimony-
come
So if you didn't post it was to go to post the bond, it was not yours. The money was to go to post the bond. It was not your money.
Well, that's not exactly correct. It was the second step in the three-step process. Bond reduction, bond posting, representation in court.
Okay, but even if I take the 3-step or 2-step or how many steps it was, the money wouldn't become yours unless it couldn't be used to put up the bond.
That's right.
Okay, so until that contingency occurred or didn't occur, the money was not for fee, it was for the bond.
The requirement to avoid what Mr. Taylor inquired about is that criminal lawyers who have a bond account with the county must sign a document that says, I represent this person. So this was all for representation, what I called the second step of the three-step representation. Since the second step was not possible because there wasn't enough money, I couldn't post a $50,000 bond for $2,750. Then I went to the third step, and I began to actively do things to try to advance his cause, which is continue to bother the assistant DA about a reduction and talk about a plea bargain agreement and go to the grand jury and try to convince them to consider not indicting him for the enhancement paragraph.
Mr. Hodges, 2 questions, and I think we're probably close to running out of time at the initial. Number one, is it and we'll look through the record here again, but is it your testimony that you explained how the $2,000 or the $2,750 would work to Wanda? In other words, the $2,750 would go to reducing the bond, assuming you could get it below $5,000, or she would need to come up with a full $5,000 for the 10% to get the bond posted, correct?
Yes, sir. Those are the first 2 steps.
Right. And if you were unable to she couldn't raise the $5,000, or you couldn't get it reduced to the amount that she could afford, did you explain to her that you would use that money for legal fees?
Absolutely.
And that was an oral conversation with
Yes.
her. Nothing in writing to show that.
No.
Now, final question is, when did she request that you return any money to her, and what was your response and why?
She requested it when she filed agreements.
But did she make a demand before she filed the grievance for the money back?
No, sir.
And what was your response?
No, sir, she did not.
Okay, and what was your response when she filed the grievance that she wanted her money back?
Well, I answered it as best I could and pretty much said in my response what I have told you folks.
So your position all along has been that it was a fee that ultimately was earned?
Yes.
Okay, thank you.
Mr. Hodges, the commission argues in its brief that we should view or look at what the panel did under a substantial evidence review. My question to you is, do you agree with that? And if you don't agree with it, how should we look at what the panel did?
Well, I believe that the panel erred in each of their conclusions. Did that answer your question?
Well, I was wondering what the commission argues, if I read the brief correctly, that we should look at what the panel did under a substantial evidence review, kind of an appellate type review that's mostly used in administrative hearings. How do you believe we should look at what the panel did? Should we just do you believe we should look at it like de novo or under some sort of scope of review? I'm just looking for what you believe.
I believe that Mrs. Laird and her son, being familiar with the criminal justice system, believed that they could get all of their money back. And according to the panel, they did get it all back, every nickel. I didn't get anything out of this except a 3-year suspension. I don't believe that their testimony was credible.
Thank you.
Any other questions? We have gone quite over, but I'll still give you your 5 minutes for rebuttal.
I shall give you some time back.
Okay, thank you. Ms. Hamill. Yes, sir.
May it please the board, good morning.
Morning.
The board should affirm the judgment of active suspension for the simple reasons that the evidence of record fully supports the judgment, and also Mr. Hodges has failed to show any error. As Mr. Hodges acknowledged in the proceedings below, the evidentiary panel found that he violated 4 different rules. And I'd like to quickly go through each one of those and discuss how the evidence supports the findings. The first one is Rule 8.04A11, and that rule prohibits a lawyer from practicing law while his license is administratively suspended. And this is the simplest of the 4 rules in this case. Mr. Hodges admitted that he practiced law while he was administratively suspended. So the facts that underlie that finding are undisputed, and that takes care of that rule.
Hamilton, let me interrupt you there. If that was the only rule that he had violated, what is your view on 3 years of an active suspension?
Considering Mr. Hodges' disciplinary history, where he's been sanctioned numerous times over his career, granted his most recent discipline took place quite a while ago, but he has been disciplined numerous times for I believe over 15 grievances in his career underlying each of those various sanctions. And he has been suspended over and over again throughout his career, sometimes for multiple years. I mean, administrative suspensions separate from disciplinary suspensions. Because of that, his practicing law, again, while he was administratively suspended, actively practicing law in this case, it is egregious misconduct. So a severe sanction would be within the panel's discretion, because an evidentiary panel, like a trial court in a disciplinary case, does have very broad discretion to determine what an appropriate sanction is.
My question really is, if we forget everything else and we just look at the administrative suspension and he is guilty of that, which I think is undisputed from his own testimony argument today, does 3 years strike you as being excessive?
I'd say it is beyond the usual sanction for practicing while administratively suspended, but this is an unusual case.
Beyond?
Because Mr. Hodges didn't raise that issue, I didn't actually go back and look, so I'm just kind of talking off the top of my head on this issue. It does seem like it's a harsher sanction than would normally be warranted in that kind of a situation. Now, normally when we are dealing with a violation for practicing while administratively suspended, it does accompany some other misconduct, and that's why we're looking at it. A grievance has usually been filed for some other reason, and so that's just, misconduct in addition to what really the heart of the grievance is. So it's hard. I can't remember a case where that was the only misconduct, and so we could really say exactly what the sanction is. But again, a panel does have very broad discretion, so if a panel did decide that was a serious enough violation with a history like this, that would probably be within the panel's discretion.
Ms. Hamilton, wasn't his ability to function on making bonds a result of his status as a lawyer?
Yes, it was, absolutely.
And thus, if he was not authorized to practice law, he could not be making bonds through his status as a lawyer.
Yes, that's correct. And so,
Getting back to Mr. Kittner's point, if you assume that the panel, the panel did give a 3-year suspension, what is the standard with respect to which we could question that suspension?
well, there is an abuse of discretion standard, if that's what you mean.
Yeah.
The standard of review for that decision is abuse of discretion, which means that the decision could only be reversed if it were arbitrary and unreasonable and not based on any appropriate guiding rules or factors.
And I guess your point is that the guiding rules and factors would include a prior disciplinary history.
Oh, that's correct, yes. Yes, and that's set forth in the rules of disciplinary procedure as a specific factor that can be considered in assessing a sanction.
Thank you.
Thank you. So there can be no question about the sufficiency of the evidence to support that because it is undisputed. Then the second rule of the 4 rules is Rule 1.14a, which requires a lawyer to hold money that belongs to clients or to third parties in a trust account. It's a fairly simple rule. And at the evidentiary hearing, Mr. Hodges admitted, as he has this morning, that he did not put any of the money that he received in this representation in a trust account. Of course, the testimony did conflict over what the nature of the funds was, with Mr. Hodges saying that it was sort of a deposit toward the full fee for his representation in the criminal matter, and Mrs. Ware and her son Byron testifying that no, actually, the money was all supposed to go toward the bond. It really doesn't matter who was correct. In either case, Mr. Hodges was required to deposit that money into his trust account. So either way you look at the evidence, it's sufficient to support that second rule violation, 1.14a. So that takes us through those first 2 rules. And then the third rule is Rule 1.03b. And that rule says that a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. In this case, it's clear from both the testimony of Mrs. Ware and the testimony from her son Byron that Mr. Hodges had not explained the terms of his agreement to represent Byron in a way that was sufficient for either of them to understand what those terms were. Both of them clearly thought that the initial $750 payment made to Mr. Hodges was for a limited purpose, and that is to seek the reduction of Byron's bond. And they were both certain that the second payment, that $2,000 payment, was for the bond itself. And they also thought that Mr. Hodges was going to refund all of that money to them if he was unsuccessful.
Counsel, one question. At page 34 of the record, when Ms. Ware was cross-examined, it says, question, and the $750 is, if the $2,000 of the $750 is going towards the bond reduction, you would agree with me some of that should be going towards his work on that, right? The answer was yes, ma'am. And then it says, so that's where I'm a little bit confused. Answer, yes, ma'am, it wasn't every penny. So is the record completely clear as to the assertion that it was just going to the bond, or whether it was sort of mixed in nature and perhaps supports Mr. Hodges' conclusion that it was to be a credit towards legal work performed?
I think that the record is clear that the Wares expected that all the money was going toward work on the bond or the bond itself once it was reduced, and that they believed if the bond didn't get reduced, then they were going to get that money back, which would be an unusual arrangement, but that was their understanding. And Mr. Hodges' description of what that money was for lends itself, it makes it understandable that they would be drawn to the conclusion that they were going to get all that money back if he was not successful in getting that bond reduced. And I think it's important to note that Mr. Hodges did testify to some informal steps he tried to take to get the bond reduced, but he never took any formal steps, never took any formal action that a lawyer would normally take in order to get a bond reduced if he had been paid to do that. He never filed a motion to get the bond reduced. He claims that this money was all supposed to go toward full representation. If he was unsuccessful in getting the bond reduced and getting Byron out of jail, the money was going to go toward the full representation, but he never even made an appearance in the case. So to say that he provided some kinds of services, some kind of legal services that were adequate to earn the money that he was paid is just something that's not supported by the record. Because essentially, from the Ware's point of view, he provided no meaningful services to them at all. Now, we know that they hired a lawyer later, a couple of months after this, who came in and did get that bond reduced and get Byron out of jail. And for whatever reason, Mr. Hodges didn't take any of the steps necessary to do that.
Is it correct that they did not request a refund except with the filing, or the first time they did was the filing of the grievance?
The evidence on that issue is conflicting in the record. At one point, the panel asks Mr. Hodges that question, and he says no, as he said this morning, that they never asked for a refund. But at another point in the record, Mr. Hodges acknowledges that, it sounds like he's acknowledging that he heard that Mrs. Ware was accusing him of stealing her money, and making it clear that she did expect a full refund of the entire $2,750. So Mr. Hodges' own statements on the record about that are conflicting.
Is it correct that there is nothing in writing from her requesting a refund prior to the filing of the grievance?
That appears to be correct, but I think that what you said at the end about prior to filing the grievance, once the grievance was filed and these proceedings began, there could be no doubt that he should have paid that money back. And I think another important part of the record in that respect is the evidence regarding Mr. Hodges' disciplinary history. And if you look at that evidence, we see that in 2000, he had an agreed partially probated suspension with a 30-day active suspension, and one of the violations involved his failure to hold funds in a trust account after his client gave him the funds to post a bond in a criminal case. He had another one in 1995 for similar misconduct where he was cited for failing to deposit an advance fee into a trust account. So he's been dealing with these kinds of issues about how he's supposed to hold client funds and how he's supposed to be dealing with those funds for many years now, and been cited repeatedly for violating those rules. So under those circumstances, I would think he'd be particularly careful to make sure that when he receives client funds, he should treat those in a certain manner, and when representation is terminated, he should be sure that he's still handling those funds the way he should, and in this case, that means by refunding them to the client.
If he had refunded the money upon receipt of the grievance, would he still have been prosecuted for that violation?
That's a scenario that's not uncommon, of course. Once a grievance is filed, a respondent will sometimes take steps to rectify whatever the problem is. In those situations, the outcome varies. Sometimes it might be that the case is settled, the matter is settled with the commission. Sometimes, though, the situation is still of a nature, the misconduct is egregious, maybe the disciplinary history is really notable, and so the commission will proceed with a disciplinary action regardless of that, but still that would be a factor in mitigation.
But he said that the $2,000 was first to go towards the bond. And if that was unsuccessful, then the second or third step, whatever step it was, then it goes towards his fee. That was his argument. So at least when he got the money initially that was to go for the bond, it was not his money.
Well, the client's understanding was that they were paying him the $750 to get the bond reduced, and
I can't follow the $750. Give me the $2,000. I can follow it.
The $2,000 is simpler. The $2,000, it's clear that the client believed that $2,000 was going to be used to pay for the actual bond.
But isn't that what he just told us a minute ago? He just told. Forget what she said. He said the $2,000 was to be used first step, second step for the bond. If that didn't work, then it was to be used to pay his fee. So at the time he got the money, whether he did anything later or not, whether it was asked for back later or anything else, at the time he got the money, it was not his money.
Absolutely correct, yes. It was not his money, and he had a responsibility to put it into his trust account. and keep it there safely, separate from his own funds. Yes.
Skipping forward then to the 115 violation, on page 37 of the record, we find a question and answer. The question is, so it sounds like it was shortly after December 14th that you find out the bond's not going to be reduced, and you go about trying to hire another attorney. And the answer is, after he, referring to Mr. Hodges, said that he wasn't able to do it, and he was going to give me my money back, and I said, when? And he said, I don't have it in my pocket. So yes, ma'am, I was under the understanding I would get that back. Is it the Commission's position that evidence is would support a substantial evidence review with respect to both 114 and 115?
Yes, that is some evidence to support that, yes. And
a reasonable basis for the decision?
Right. And it's clear a little earlier in the record that Mr. Hodges himself acknowledged that he told Mrs. Ware at the point that she brought him the $2,000, he says that he explained to her that he wasn't able to get the bond reduced, and so she gave him the $2,000. And he acknowledges that she didn't understand. There was some misunderstanding on her part about what was happening, which is fairly obvious from that chain of events itself. She would not have given him that $2,000 if she understood at that point that he couldn't get the bond reduced. You know, she testified unequivocally that that's what that $2,000 was for. She thought he had gotten it reduced at that point, and he was going to take that money and then immediately get her son out of jail with it. So there was clearly misunderstanding there about what was happening, and it was there. Her testimony and Byron's testimony is clear and convincing that they always expected that $2,000 to be used for nothing but paying a bond premium. All right, so that takes us really through all four of the rules at issue. In the final analysis, it's clear that the evidence supports the findings underlying all four of the violations that were found by the panel, and Mr. Hodges hasn't shown that any error actually occurred, much less any reversible error, and so we urge the board to affirm the judgment in all respects.
Quick question on his final sentence in his brief asked for a reduction of time, and I don't know where Appellee's brief addressed that, except that it wants everything affirmed. I want it cleared. Is it the Appellee's position that this panel can change the time, or that it would have to send that back?
Well, I think there's a two-part answer to that question. There are circumstances under which the board could modify a judgment and affirm it as modified. The board could do that. This case doesn't present a situation where that would be the appropriate action, because that's not an issue that Mr. Hodges raised in his brief in a way that was adequate to put it at issue before the board. He didn't show any error in the way the panel assessed the sanction. He included, I believe, just a sort of a prayer there at the end, but never really addressed any basis, never talked about what the record shows in regard to the sanction and why the sanction is inappropriate, never talked about the law in regard to a panel's authority to sanction and why under that law the panel's decision would be inappropriate. He didn't brief any of those things in a way that really puts them before the board today. And for that reason, the board shouldn't touch that sanction.
Ms. Hamilton, the 114 rule says, of course, you have it reprinted in your brief, and it talks in terms of property that a lawyer should hold when a lawyer holds or funds in connection with the representation. You know, I've got a lot of dots in my right. What's your view of the lawyer's duties if he or she is not holding money of another in connection with representation?
I'm not sure I understand the question.
Yeah, and it's probably because it's not a very good question.
We'll stipulate to that.
That's often the case. It's often the case. But what happens? We've got this kind of issue of bond. They thought, the the record shows that the clients thought the money was for purposes of getting a bond. If that bonding money was not in connection with Mr. Hodges' representation as a lawyer, do you think the duties change under 114 because it's not in connection with the representation, or does it stay the same? What's your thinking on that?
No, probably because of the language of 114, it applies to money that is held in connection with the representation.
Okay, and what if it's not in connection with the representation?
Well, there still are rules that could potentially come into play if a lawyer is holding money that belongs to somebody and he misuses that money, but it's not in connection with the representation. The rule that comes to mind is the rule that prohibits a lawyer from engaging in conduct that involves dishonesty, fraud, deceit, or misrepresentation. You can see how that might come into play in regard to a lawyer holding money for another person, not in connection with the representation. There could possibly even be some kind of criminal conduct in
But
regard
as to
to
114, the finding of the panel, 114 violation, if you're just and I appreciate your points; they're all well taken. I mean, they're good points. But as to 114, if it's not in connection with the representation, what does that do to a 114, an allegation of a 114 violation?
Well, presumably the commission wouldn't make an allege a 114A violation if the money wasn't being held in connection with the representation. So if a client comes in and I'm saying client, if a third party comes in, for example, and complains about the way a lawyer handled money that the lawyer was holding for that person, so it would depend on exactly what the specific allegations are as to whether that does fit under some other rule, like 8.04A, because of course the rules do apply to a lawyer's conduct outside the practice of law in some instances. Now, it's very rare, almost unheard of, for us to actually bring a disciplinary case involving conduct completely separate from a lawyer's work as a lawyer, but the rules do provide for that.
Doesn't the rule apply on a simpler basis than that? The only reason that the lawyer could provide the bonding service in this case and in many others was through their status as a lawyer.
That is correct.
So in essence, if it's just for a bond, isn't it a limited scope representation for purposes of providing the bond? And thus the money must go into an IOLTA account.
Yes, that is correct. And in this case, there's no question that he was holding that money in connection with legal representation. That's why these people came to him. They came to him in his capacity as a lawyer and said, use your legal knowledge to help us get this bond reduced and wend our way through this kind of complicated system, this complicated aspect of the criminal justice system, and get us what we need. They came to him as a lawyer. There's no doubt he was acting as a lawyer here.
But at the hearing, didn't she testify that all she wanted him to do was make the bond?
Absolutely. Absolutely. And the commission's position on that is that's all she hired him for, separate from the representation, the defense of the criminal charges, but still hired him in his capacity as a lawyer to do this work for Byron. That's why he was hired.
Bondsmen do this all the time. They'll take partial payment, and then they'll say, when you bring the rest of the money in, I'll bond your kid out of jail.
That's correct.
Do you agree with that?
And you can do that if you're a bondsman, and you can do it if you're a lawyer. And Mr. Hodges was hired because he was a lawyer, and he couldn't have taken on, this service. He couldn't have agreed to provide this service if he weren't a lawyer.
Did she think he was working for free?
I don't think she thought he was working for free, but I think that she expected if he didn't do anything for her, if he wasn't able to do anything, then she would get her money back.
You don't guarantee services. She said, I'm hiring you as my lawyer to get the bond reduced. He tries to reduce the bond, he doesn't get it reduced. Just because he wasn't successful doesn't mean she doesn't owe anything, does he?
That's correct, but
So how was she going to pay for this fee,
but
this service?
based on the record, it doesn't appear that he provided any meaningful service to the client at all. For example, he didn't file a motion to reduce the bond. He never even made an appearance in any way in the case, whether it was just in connection with the bond or otherwise.
But her claim is that the money was not, that she didn't hire him to be a lawyer. Her claim is, I only wanted him to get the bond reduced. Forget what he did or didn't. That was what so he was hired as a lawyer to get the bond reduced.
Correct.
Was that free? Was that going to be free? She said that's what the $2,000 was for. Was she ever going to pay him anything for anything?
Based on what's in the record, and the record doesn't go into a lot of detail about exactly what the understanding was regarding the $750, it looks like Mr. Hodges never made that clear. He acknowledged that he would take that $750 if he were successful in getting the bond reduced and put it toward the bond, which didn't make a lot of sense because it would essentially leave him without any remuneration for the service that he provided. But it looks like that's the agreement that he made, perhaps then assuming that he would be hired to defend the criminal charges and be repaid then. But Mr. Hodges himself acknowledged that that was the plan, that he was going to put all the money toward the bond.
I'm just trying to get at what her state of mind is, whether he, following up on Mr. Cruz's questions, whether he was a lawyer or not a lawyer.
Well,
or acting as a lawyer. Or not.
If you kind of read between the lines, it looks like Mrs. Ware and Byron expected that the $750 was the payment to him. They thought that the bond was going to be reduced to $20,000, and then they thought they had to come up with 10% of that, and that would be the $2,000. So it looks like that's what they assumed, not really ever understanding exactly what the terms were, because Mr. Hodges didn't make those clear to them. It sounded like, according to his testimony, he envisioned quite a complicated arrangement here, but didn't take steps to make sure that his client understood that, especially by his failure to put that in writing made it very difficult for his clients or anybody really to comprehend such a complicated arrangement. And that's one of the basic problems here. So they ended up losing all this money for nothing because they really got nothing for it. That's not what they intended, and they never understood that that might be a potential outcome.
Let's stick with the $2,000. Suppose he'd have gotten the bond reduced to $20,000 and he used the $2,000 to get the bond. Does she owe him any money?
Well, she had paid him $750.
I can't figure that $750. It's so complicated. Forget about the $750. On the $2,000, he got the bond. She gave him the $2,000. He used it all for the bond. Does she owe him anything?
Well, according to her clear testimony and Byron's testimony, they believed that the entire $2,000 was going to pay for the bond, that none of that was going to go to Mr. Hodges for anything. That's what they thought.
And at page 35 of the record, she testifies to exactly that.
So whether he actually was acting in a legal capacity, she didn't hire him to act in that capacity. That was not her attitude towards him. You're not my lawyer.
No, and she even says in her testimony she hired him as a lawyer, and she went to him as a lawyer, and she never expected a lawyer to treat her the way that she was treated. So it was foremost in her mind that she was hiring him as a lawyer.
Here, let me ask this question, though. We keep referring to they and to her, but the client was Byron, right?
That's correct,
okay.
yes.
And Byron, this wasn't his first rodeo down the felony trail, and so the deal talking about how he didn't understand after being in jail at least 9 times, but that's the argument that's being made. He didn't really understand that, but so much of this conversation was taking place with his mom that wasn't the actual client, right?
That's correct. She was the conduit for much of the information, most of the information. And I just want to point out, too, this discussion of Byron's criminal record, none of that is in the record. There is some mention and acknowledgement of his having a criminal history, but there is nothing to hint at something like 9 felonies. I don't doubt that Mr. Hodges is telling the truth about that, but there is nothing in the record to substantiate what Byron's criminal history was.
Well, we know at least he has one enhancement paragraph, so at least that's in the record.
There's some reference to that in the record. There's very little information about what exactly these charges were or what his criminal history was. All right. Thank you very much.
Thank you, Ms. Hamilton. Mr. Hodges, if you'd like your last 5 minutes.
I'll be brief.
Mr. Hodges, before you begin, I want to ask you about the situation where Ms. Hamilton says that this has occurred to you in the past on your several reprimands or suspensions. This was, to quote our esteemed chairs, wasn't your first rodeo with this type of situation. How do you respond to that?
I was going to respond to that.
Thank you.
In the 80s, I was a civil lawyer, did not do a criminal case at all. I was clinically depressed. I was in treatment for probably a year, one-on-one treatment. However, when those complaints were made against me, and I think they were well-founded, I did not tell the procedures changed a lot since then, but I didn't tell the fact finder anyway. And the only reason I can tell you that is I was just being macho. I thought I can handle this. You know, I'm a big boy. I don't need to use a crutch. And I was suspended for 12 months. After the 12, and I completed that. And after that was over, the bar came back with some more of the things that had come up before I was originally suspended. I was out of money. I took the 15-month suspension. But this was not for anything new. All these things were before the 12-month suspension. After that, I have to live the rest of my life with the 12-month and the 15-month suspension. So when criminals who tend to blame everybody but themselves for what's going on file grievances all the time. And twice I was called in and I agreed with the representative of the bar at that time to take a 1-month active suspension because I didn't want to go through that. I didn't want to take a chance of something horrible happening to me like happened today or back in April of last year. And so I took 1-month suspensions with the probated term and I lived them out like a champ. I didn't have any problem with that. So I hope that answers your question.
Well, let me follow up with another question because, and I think this is what was asked at the end. Let's assume that she had paid you the $5,000 or whatever the number was, and you posted that as the 10%, and she had said to you, "Thank you very much, I appreciate it." Would you have charged her a fee at that point? What would you have done? What did you earn?
I would have told her that you have paid me for what I've done so far. Do you want me to do anything else? If you do, we need to make an agreement.
Well, but the $5,000 went to the bond. Now, are you saying if that he goes off the bond, you get the $5,000 back and you keep it and that's your fee?
No.
I don't know how it works.
No. Well, you have to give the county some money. Give them $1,000, you write $10,000 worth of bonds. If $5,000 bond is released, you still have $1,000 for $5,000 worth of bonds, so you don't get any money back. You'd have to get it down less than $1,000. So the fact that someone is released from bond usually makes no difference whatsoever.
Okay, so my question is, what if she had said, "Thank you very much, I really appreciate you taking my $5,000 and getting him off on bond, I don't need you anymore"?
I would have said, if you want any more help, let's talk about it. If not, I'm
but
glad I
what fee
did a
have
good
you earned
job.
at that point? Because it sounds like all the money went to the bond.
Well, no, I had to charge for what I did. Being responsible for $50,000 bond, I have to have at least $5,000 on deposit with the county. And so I wouldn't get it back.
I understand you wouldn't get it back, but I'm just trying to, how did money go into your pocket under that scenario?
It would, well, if I already had enough money with the county to post a $50,000 bond, it goes in my pocket. If I don't have enough in there, I have to give them some more in increments of 1,000. So the answer to your question is maybe yes, maybe no.
I think I understand. Thank you.
Sir, I just want to tell you that Mrs. Ware and her son did not make any mistake as to what was going on. They want their money back. There was a lot of conflict in the testimony, and I suggest to you that their testimony is not credible. With his previous record and him saying that he had a stroke, he had a mental illness, that he was sick, that he cried the whole time I was there, I don't think that he's capable of making a rational statement. Now, I dealt with the suspended. Counsel was just speculating about if there was $20,000 bond and they gave me $2,000 that posted, that didn't come up. It didn't happen. It's not in the record. That's just grabbed from the sky. That didn't occur at all. I know my time is up. I'm asking you to set aside the findings of the board. If you do not think that's appropriate, then I'm asking you to give me a reduction to a reasonable amount. And understand, I've been suspended for 15 and a half months. I've been out a long time. I lost everything. Everything. I lost my house, my office, my employee. I lost 60 pounds the first 3 months. I wasn't sure if I was going to live. I cannot find any kind of employment for me, for a 70-year-old suspended lawyer. I'm living on $650 a month Social Security. I can't pay fine. I don't think that the Wares are entitled to restitution. I told you I'd try to give you some time back. I will. That's all I have. Thank you very much for your attention and your consideration.
Thank you.
Thank you, Mr. Hodges. We will take that matter under advisement, and we will advise you and the commission of our decision.
Thank you very much.
Thank you. You're excused, and I'll ask that